All right, court is calling 2022 CR 2397, State of Texas versus Wilfredo Salgado Salinas. Can I have parties announced for the record for the state?
Daniel Escobar for the state.
Stephanie Collins for the defense.
And are you Mr. Salinas?
See.
Yes.
All right, we have an interpreter with us. If you can raise your right hand for me, please. Do you solemnly swear or affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right, so the first thing, my understanding is that he is requesting a jury trial. Is that correct?
Judge, before we reach that matter, I would like to ask the court to ensure that Mr. Salinas is desiring us to represent him. I know this was a question before, but before we proceed to jury trial, I think I need to put it on the record again if he wants us to represent him or not.
Oh, well, what I can tell everyone, this is an old case. I know that your firm was wanting to withdraw and that motion was filed and the court denied it. And if he wants another attorney and does not want you to represent him, then he needs to have an attorney who's prepared for trial tomorrow, because this specific case will be going to trial tomorrow.
Judge, he has been trying to fire us for 2 months.
Mhm.
And we did not attempt to withdraw on our own request. We attempted to withdraw because he asked us to, and he's been asking the court to appoint him an attorney since July 25th.
No, he has not.
Those motions are in the file.
No, he has not been asking for this court to appoint him an attorney. And if my understanding is, one, you have not been the attorney who's been on this case. There's been another attorney from your firm. And where is that attorney? Because
Judge,
that's the
he's
attorney.
resigned.
No, that attorney needs to be here because he's listed as his attorney.
Anthony Wilson, or is that who you're speaking of?
No,
Judge?
I'm speaking
Carlos
of,
Ramirez?
yes, where is
Okay.
he?
I'm not sure. I think he is down taking care of other business.
He needs to come up here and take care of this business.
Okay, but Judge, I did see in Odyssey that there's been some pro se motions filed requesting an appointed attorney.
Let me just explain to everybody how pro se motions work. When somebody has retained counsel, their pretrial motions are not heard by the court.
Of
Their
course,
pretrial motions are only heard if they are pro se. He is not pro se. And Carlos Ramirez, who has been here, needs to be here. He knew that this was here,
sure.
so I do not understand why he's not present.
Okay, but the issue that we need to determine is if he, just for the sake of trial, and I understand, Judge, that you're gonna call this case tomorrow regardless, but for his sake and ours, I need to put on the record if he is wanting us to represent him at trial.
All right, so what I'm telling you is the person to be asked those questions and to put it on the record is Carlos Ramirez, not you.
Well, I am also listed as attorney of record, Judge.
Well, I'll have them check to see if that's the case. Ms. Ferguson, can you look and see if she's listed as an attorney of record? Or is it just their firm? And are you Stephanie?
Yes.
All right, ask.
Oh, the performance was priceless. Watching someone try to outsmart the court with excuses so flimsy they couldn't even hold up a paper napkin. The judge didn't even need to break a sweat. One raised eyebrow and a couple of sharp lines were enough to turn the whole act into a comedy show. It's almost unfair, like bringing a water gun to a wildfire. These defendants show up with stories that collapse faster than a cheap lawn chair, and all it takes is a calm, cutting remark to remind them that logic, truth, and the law aren't optional accessories.
Your questions.
Mr. Salinas Salgado, before this goes on, Judge, I would also object to this being broadcast on YouTube in the event that potential jurors are watching this right now, knowing that they're gonna be called to this court tomorrow.
Mhm.
I think that would be prejudicial, Judge.
All right, your objection is overruled. Do you have questions for him?
And I would object to the overrulement for the record. Mr. Salinas.
Just a moment. So this is how things work. You make your objections, I make a ruling. There is no, I object to the court's ruling. The court's ruling is the court's ruling. And if you're intending to preserve error, how you preserve error is you make a request, I make a ruling. That's your error. It's preserved. Preserving your error is not if I overrule an objection or I sustain an objection and you say, well, I'm objecting to your overruling or sustaining an objection. Legally, that's not how things work. So your objection to the broadcast is overruled. Now, here's my question. Is he going, if he were to be found guilty, is he going to the court for punishment or is he going to the jury for punishment?
We have filed a motion for jury, but I still need to determine if he wants us to represent him or not.
All right, so this is what I need you to do. I need you to listen to my questions, answer my questions, and we will go in the order that I'm giving you. So, Mr. Salinas, do you understand this process? Have they explained to you about jury trial? Well, let me strike that question. Don't answer that question. Let me explain to you. In this court, since you've been here, this is the process for this court. First thing that happens is I make sure that defense attorneys have all of the discovery. What is discovery? Discovery is items or evidence or proposed evidence about your case. So if there's a video that's about your case, the defense is entitled to have that. And I make sure that they have that. And if it's something that they say they don't have or something that they think they should have, and maybe the state has and hasn't turned it over to them, I'll make sure that they have that. So in your case, your attorney has said they have all of the discovery. So that means that all of the evidence that you're entitled to, they have that. Your attorney, Mr. Ramirez, has said that's the case. Then the next thing I do is I tell the state in this court that you have to tender an offer. That offer will be given to your attorney. That attorney will go over that offer with you. And then if there's something you don't understand about the offer, then you're to ask your counsel. Do you understand? Okay.
Yes.
So yes or no, has an offer been tendered to you in this case?
No.
No.
All right, so this is what we're gonna do. I'm gonna have you sit down. The state will let this defense attorney know, because I know this defense attorney hasn't been here. It's been Carlos Ramirez. The state will let them know what the offer is. And then your attorney, who's here today, will let you know what the state's offer is. Then you will let me know whether or not you're accepting the state's offer or whether or not you wish to go to jury trial. Do you understand?
See.
Yes.
All right. If you do not reach an agreement, this will be going to jury trial. And what that means is a jury will be in the hallway at 10 o'clock. And then we will start jury selection. But the first step, the state is going to give the attorney here what their offer is to you. And then you will come back and let me know whether or not you're accepting that offer. Do you understand?
Yes, okay.
And there it was again, the masterclass in courtroom reality checks. While the defense tried to turn objections into a dramatic encore, the judge calmly reminded them this wasn't amateur hour at a debate club. This was court, where rulings aren't suggestions up for negotiation. Watching that order get laid out step by step, like a teacher explaining crayons to kindergartners, was almost entertaining. Every move was precise. Evidence? Check. Offer? Check. Jury trial? Check. Meanwhile, the defense looked like they were still trying to find the rule book.
Okay, thank you. We're off the record. How do you say okay in Spanish?
Okay.
Okay, all right. See, usually, no, that's fine.
Está bien, okay, yeah.
See, in French, it's d'accord. So I always thought there was some way to say it.
Perdón también. That's a good.
Okay,
There's so
that's-
many ways to say it.
All right, but you know what? I like saying Spanish, okay?
Okay.
So when people ask me if I speak Spanish, I can say,
Okay.
yes, I do, okay. All right, so have a seat
Tome asiento.
and state if you'll make sure she has the offer.
Okay.
All right. So Sharon Cardenas. And then there's a request for no broadcasting. Is that correct?
That is correct.
All right. So the court has read the defense's motion, and what I can tell the defense is, number one, the court limits the number of people in the courtroom for security reasons, also for health reasons. I think everybody is aware of the brawl, for want of a better word, brawl, skirmish, or whatever that occurred in the other courtroom. As everybody is aware, there are only a limited number of deputies. I have 2 deputies in this courtroom, and we almost had another incident here today that I think would have turned quite differently if the courtroom were packed. The court must have an open courtroom to the public, and that is how the courtroom is keeping it open to the public. So I read your motion, and that motion is denied.
Your Honor, may I make a little bit of a record on that?
Sure.
Okay. And so Ms. Schnitz has some specific things that have affected her as a result of the broadcast over YouTube. And specifically, Your Honor, the open courts, one, we don't think that you need to close the courtroom to non-participants. So we object to the closing of the courtroom, which we were just made aware of this morning. So we have that objection. We think the courtroom should be open to live audience members. Ms. Schnitz is in a very particular situation. She's in a custody battle at the time, currently, and her ex-husband monitors these YouTube videos. He saves them and broadcasts her information to her friends and family and uses it in her child custody case. Additionally, Your Honor, so I'm going to have Ms. Schnitz speak to that if she could.
Sure. Can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Shali, Shali Schnitz.
All right, thank you. You may question.
Are you concerned about being broadcast on YouTube?
Yes, I'm very concerned.
And can you tell the court why?
I'm very concerned because my ex-husband, the husband of my daughter, who is,
I'm sorry, the father of your daughter?
oh, the father, I'm sorry, has been, he is being investigated currently for abuse of her sexual assault and numerous counts, a very, very serious situation. And he is using the YouTube videos, and he's explained that in emails to watch what is happening on court to find the location of my daughter. And I'm sorry.
So also,
And just like that, the attempt to derail the process with emotional theatrics ran into a brick wall of courtroom reality. The judge didn't flinch, didn't waffle, didn't let the drama dictate the law, just calmly reminded everyone that open court isn't a pick and choose policy, it's a constitutional mandate. Security concerns? Addressed. Health concerns? Addressed. Transparency? Upheld. Meanwhile, the defense was out here treating objections like plot twists, hoping passion could trump procedure. Spoiler, it can't.
he would come in person before, correct?
Yes, sir.
Okay. And now he knows where you are because he can watch the broadcast. Is that right?
Yes, ma'am.
Oh.
I mean, yes, sir.
And when you additionally, you've had to talk about your treatment situation. You're addressing your alcohol issue. We've had to do that in open court previously. Is that right?
Yes, sir.
And has he recorded those to your knowledge?
Yes, he records those as well.
And he lets other people know who are involved in your case?
Yes, he lets over 20 people know and places it on social media and sends it out.
Okay, and that's everywhere from Governor Abbott to Joe Gonzalez to everybody that is also the principal of your daughter's school. Is that right?
Yes, sir.
Okay. And so at this point, you're left with a choice of either terminating these proceedings by entering a guilty plea or continuing to be broadcast on YouTube.
Yes,
Okay, and that's the choice that you're currently facing. Is that right?
yes.
All right. Do you want to be broadcast on YouTube?
No, sir. It's very scary for me, terrifying.
No, that's all right. I have no further
Any
questions.
questions?
Nothing to say, Judge.
All right, and the court will state again, everyone is aware of the brawl, skirmish, whatever you want to call it, that took place in this courthouse recently. No less then I think 10 deputies or maybe more were summoned. There was a fight in the jury box where audience members came from the audience and attacked someone, and I will use the word allegedly, but I think everybody has is aware of it. An inmate that was in the box. We just had what could have been a bad incident in this court today where deputies had to step in and escort somebody out of this courtroom. This is a court that needs to be open to the public. I am not going to allow people in the courtroom for safety reasons. I'm not allowing people in the courtroom unless they are a defendant, a person accused, or unless they are a witness, and those witnesses will be brought in when they are needed. The state will tell you, and other persons in this courtroom will tell you, anyone who is given victim impact, they can come in when it's time for them to give victim impact. But that is the way this courtroom will be run. So for security issues, we only have 2 deputies in a courtroom, and we have a third, I'm sorry, sort of a third. And I say third because he's wearing his jacket, right? But he's not assigned to this courtroom. So when you think about it, right now we have 1, 2, 3, 4, 5 people in the box. And really normally only 2 deputies. And sometimes we have 10 people in the box. So the motion is denied. And we're going to come back
And Your Honor,
on December 12th.
just one other question. Could you admonish people not to record the broadcast?
Oh, people, I am not in charge of broadcasting.
But so
So-
what happens is people will capture, like they'll capture this event, they'll put it on other platforms.
And what I can tell you, counsel, is in this courtroom with your client, I have never asked, nobody's ever asked, if I'm wrong, tell me I'm wrong. Nobody's ever asked what school her child is at or asked any of that nature. With regards to a civil case, that's something that needs to be addressed civilly. This is a criminal court.
But what happens, Your Honor, and the problem is that this is now, the YouTube broadcast is as much an official record as the court reporters.
No, it's
Transcript.
not. The court reporter's record is the official record. I made my ruling. You all are coming back on December 12th. On December 12th, I expect everyone to have their discovery in order. If there's more time that's needed to look at a vehicle, let the court know. If there's some issues with the blood, let the court know before the December 12th setting. All right, Ernest Morales.
Thank you, Your Honor.
And there it was again, the perfect display of patience wrapped in iron. While defense counsel spun circles about YouTube conspiracies and civil custody drama, the bench calmly dragged everything back to reality. This is a criminal courtroom, not Facebook Live therapy hour. Safety, addressed. Transparency, maintained. Authority, unshaken. And when the Hail Mary request came, could you admonish the internet not to record things? The answer landed like a sledgehammer of common sense. The court controls the courtroom, not the entire digital universe.